Welcome to the Landlord Zone podcast, and this week it's the final days of Section 21. What we're seeing on the ground, and who else could we ask but Paul Sowerbutts, Head of Legal. How are you?
I'm all right, Paul.
Good. And I'm Paul Shamplina, founder of Landlord Action. We've been going 26 years at Landlord Action, and we know what's happening on the ground. And on this week's episode, we'll be covering about the boots on the ground of what's happening with landlords and why they've been serving Section 21 notices. Focus on what the final rush has been relating to the abolishment of Section 21, common landlord mistakes, which we're seeing a lot at Landlord Action, the implementation of the new ground 1A of selling your property, the court delays and bailiff issues, which have been ongoing for a long, long time, and practical rights for landlords moving forward in the new world of renters' rights. So, Paul, the final rush, the D-Day, was the 30th of April, 2026. Weeks leading up to that, we saw a massive spike of activity at Landlord Action. What happened?
Yeah, it was crazy. It was sort of 3-4 times our usual volumes. Big spike. We'd expected it, so we were geared up. But yeah, landlords were sort of concerned, uncertain. There was panic, I'd say, to a certain extent. But there was that sort of general sort of now or never feel about it. Obviously, our advice was you've got a certain period of time to get the documentation in order for us to serve notices, and then also just to say to landlords, look, is there another way around this? You've left this a bit late, as it were. But yeah, generally it was just. Panic sounds a bit over the top, but I think they were concerned.
That is the reality. But why was there landlord panic? What was that?
Yeah, because the landlords realised that they weren't able to use a Section 21 again after the 30th of April. And so therefore, the situation where you convict a tenant for no fault, don't have to give a ground, don't have to give a reason, that's gone by the 30th of April. So once that sort of was, that realisation hit home, landlords started to contact us and say, look, can you help us out? I need to take action. I mean, the motivations behind it, I think there were a lot that want to sell. So to a certain extent, you say, well, there is another ground coming along, but it has its own.
But I want hearing dates and filing evidence. But I think it's not just that. I mean, I was calling it 5-6 years ago. That's when I first saw the white paper. And I said the abolishment of Section 21 was going to be up there with the implementation of the abolishment of mortgage interest relief. I thought it was that high because landlords need confidence, and they're not getting confidence maybe from government policies across from Conservatives to Labour and everything that's coming through, rising costs, much more regulation. And of course, you need confidence in the court to make sure you get your property back. And some landlords are tired and they've just said, that's enough. Yeah. Is that what you've seen?
Yeah, definitely. There was that sort of element. And for me as a solicitor, it has been there for the whole of my career. So, I've lived and breathed Section 21 ever since I qualified. So, yeah, from that point of view, for me personally, it was a big thing. Speaking to landlords, yeah, I think there are a lot that have sort of see this, if not fed up, they see this as a point at which to say, right, okay, I'm going to exit. I've done my bit, as it were.
And of course, what happens with that, Paul, is, and I said this when I did my campaign and I saw my local MP, because I was worried about landlord panic and a reduction of stock, is that good tenants are being asked to leave because they were always paying the rent, and a tenant is driven by the property, not by the landlord. And of course, I've always said, and I think it is happening now, it will get worse before it gets better for tenants. Is that fair enough to say?
Yeah, I think that's true. I think that's an unintended consequence, obviously, of there being less properties available, making things worse, perhaps rent going up. Look, in the end, I suppose there's faith in the market. It will sort of correct itself, but there's a period of time. There's no doubt about that. There's going to be a period of time. Who knows how long that's going to be, where it's going to be tough.
So, Paul, classic mistakes what landlords are still making, even right up to the deadline day. What we do at Landlord Action, and we've got 24 staff and it's all done fixed fees, and like I said, we've been doing this for 26 years, is obviously the caseworkers, the paralegals and the solicitors, they have to check the paperwork coming in under the Deregulation Act. There's obviously various different pitfalls that landlords can get wrong. What are the usual mistakes that landlords are making we're seeing at Landlord Action?
You'd think it would be difficult to make mistakes, for example, on deposit protection because it's been around for quite a while. But yeah, I'm afraid there are some sort of, well, not protecting your deposit, obviously, that's a complete failure. And advising landlords how to get around that is one of the problems. A lot of people do know about deposit protection, but there has been case law, so there's something you can't really foresee. So the one that sort of come up, the last 6-12 months, you may well be aware of you've got your deposit certificate, you've got prescribed information, and the two documents do link. And there's a little paragraph where you're supposed to fill it out. Unfortunately, a judge spotted it, and it became a problem that judges were picking out. You've actually got to say in the prescribed information which clause it is. There was even one judge said that we'd sort of referred to 2 or 3 clauses because that was the section in the contract, and the judge said, well, it's only one clause. I mean, these silly mistakes or tiny mistakes are being picked up on. So that was making sure every T is crossed and I is dotted. You can't really.
What's the issue with the gas safety certificate?
Yeah.
There's a test case.
Absolutely.
Explain where we're at with regard to that.
Right. Okay. So in a nutshell, if you haven't given a gas safety certificate or produced a gas safety certificate to provide to the tenant as they move into the property, regardless of the Deregulation Act, which is a specific point that was made in
prior to that date.
Yeah, exactly. So I think the case went to the Court of Appeal, Muka and L.R. Manny. Basically, the tenancy began in 2008, so way before Deregulation Act. They didn't even have a gas safety certificate. I think
it wasn't needed.
It wasn't needed, and but the interpretation by the Court of Appeal. I mean, I suppose there's a potential of it going further, but the position at the moment is essentially if you don't have that gas safety certificate, you're not going to get your property back. I mean, the position where
you can't undo that, then, can you?
No, it's not remediable.
It's not remediable. I mean, that's a massive change, but that's going to Court of Appeal, is it?
Is that Court of Appeal, but it may go to the Supreme Court. It's only just come out, so we'll have to wait and see. It does mean that if you haven't done it, you're not going to get your property back.
Bearing in mind Section 21.
But we're in the new world, exactly.
Yes.
So to a certain extent, I mean, the world that we're in at the moment is between phases, between the government roadmap, between phases effectively 1 and 2, I think, where we are. With the database hasn't come in yet. But when the database comes in, there may be a requirement to have a gas safety certificate, and all that previous legislation will apply. At the moment, you don't need to have, there's no Section 21, so the gas safety certificate isn't having too much of an impact, although there are those Section 21 still going through.
And what about EPC, the electrical performance certificates? What are we seeing, the classic problems that landlords are doing when they're coming to...
Yeah, I mean, I think the problem for that is not so much the documentation, it's the getting of it. So if a tenant starts refusing to give access, you've got to, how do you get an EPC? It would have been the case, I think, not that long ago, where you could sort of say, I can't get access, I've tried my best, and the judge would say, fair enough, you don't. Now it's much more, well, have you tried to get an injunction, for example? And those sorts of things, judges are looking for you to have done that. Again, it won't apply necessarily in the new world, although come the database, it might be something that's going to be required.
And then lastly, how to rent guides. They're being scrapped, aren't they? Because the legislation's coming in the 1st of May.
Yeah.
Explain that.
Yeah, so basically the written statement and information sheet is going to take over. Yeah. You've got a few days to do your information sheet and witness statement, it being the 28th today, and the deadline being the 31st of May. But essentially, they sort of supersede the How to Rent Guide. The problems with the How to Rent Guide, I suppose the main one is that that's come up quite a lot. You serve a notice, you've got it wrong for some reason, you then re-serve, but you sort of use the old How to Rent Guide if you're following the
misdated one.
I misdated one. Having said that, we haven't had one since 2023, so it's difficult to make that mistake, but it does happen, and so just everything's got its own particular twist and that's how to rent twist, although they are going.
So, Paul, we talk about landlord panic, and, I've been talking about non-stop in the press.
Yep.
The panic, the D-Day was obviously the 30th of April, 2026, to serve this Section 21. What are the talking points? What actually did you see on the ground with your colleagues?
Well, so we had, as I was saying earlier, we've got these problems with paperwork, but in that week, we had landlords coming to us, and, there might be another sort of a spike, as we're calling it in the office, later on in the year. So something to bear in mind is that people were coming to us in that last week, let's say on the Monday, saying, look, I haven't got my documentation sorted out. Can you fix it? We then do that, but then we say, well, hold on. Once we've fixed it, you've still got to serve it. You've still got to make sure it actually gets to the tenant, in that case, before the 30th of April. And I think landlords just weren't factoring that in. So there was this sort of practical thing that just get the documentation fixed, but then you've actually got to serve it. Who's going to do that? Process servers are available, obviously. They were inundated as well. I have to say, we were sort of really pulling all the strings to get these notices served. But yeah, there's a two-stage process. There's the paperwork, and then you've actually got to get the notice, the paperwork, in the hands of the tenant. So that was one of the big panic points.
So, Paul, the 1st of May is here and gone. Mm-hmm. Okay, we're now in the new regulation of renters' rights. We don't have fixed-term tenancies. We have a short periodic tenancies. There's no end date. And now, obviously, there's the implementation of Ground 1A. 1 and 1A. 1 is a family member. Ground 1A is if you want to sell the property. Explain the process, the timings, the notice period, what landlords have to do now if they want a family member to move in, or if they want to sell the property, and what you can and can't do.
Right. So, I mean, in a nutshell, for both notices, whether you want to move in or whether you want to sell, you've got to give a notice. It's 4 months. And the once you've served that notice...
A Section 8 notice.
A Section 8 notice on one of those grounds. Once you've served that notice, you then can't re-let the property for effectively 16 months. So you serve the notice, 4 months notice to expire, and then 12 months after that, you're not allowed to re-let the property, and there are fines and restrictions there. So they're the two important numbers, I think. 4 months notice, and then 16 months not re-letting for that period.
So, Paul, what happens if the tenant's moved in now? So they've got a short periodic tenancy. So obviously, how long do they have to be there before you can serve a Section 8 1A when the landlord decides they want to sell?
Yeah, Section 8 1A or Section 1, you can serve a notice after 8 months if they moved in today. The point being is that the notice is 4 months. So if you serve it after 8 months, 4 months' time, it will expire on the 12th month. And that's the law, that you can't sort of issue proceedings.
And you've got to hope the tenant gives you access to be able to try and sell.
Absolutely, yes, exactly. That's if you're selling, you got to do viewings. That's an issue. I had one this week. In fact, the agent was saying, well, what's the point in doing it at this moment, because the tenant won't give you access. So I was advising around that. But yes, so essentially it's 8 months after the tenancy begins. If the tenant's already started, so before the 1st of May, you entered into an AST, let's say in January, for 12 months, you know that on the 1st of May, it converted automatically. You didn't have to do anything to an APT, a short periodic tenancy. But the time before the 1st of May counts towards that 12 months that I was talking to you beforehand.
And what evidence does the landlord need?
So this is new legislation. So a definitive answer, and I've seen quite a lot of people talk about this in the various forums and whatever. My advice is to, at the very least, have an instruction letter from an estate agent. If you've got that, they will. So you've instructed the estate agent; they've given you one of their standard letters saying you are now a client of ours. We are going to sell the property for you on such and such a date. I think that's pretty good evidence that you intend, because that's all it is. You intend to sell the property. Now, if a tenant were to say they don't believe that intention, that you've just made it up, you can say, well, I've got this estate agent. They said, well, anyone can do that. Estate agents can.
Well, if they don't believe you, you can say, well, let me do viewings.
Well, yes, that's true. That's true. But what we're advising, just for this initial period, we're saying to clients, the old DREG documents, I think, will really come in handy here. They're a bit of a pain. Gas safe certificate, how to rent guys, all those things. If you provide all of that, not necessarily with the notice, but if you go to court, then you can show to the judge that you're an upstanding, honest landlord, and then it will sort of give your intention, your word, more weight.
So let's play this out. So you serve a notice, the tenant doesn't leave after 12 months, then presumably the landlord has to issue court proceedings. They have to get a hearing date. They have to go to court. They have to instruct a solicitor, someone like Landlord Action. You have to provide the evidence. You have a hearing date. You have to get your possession order. Then if the tenant still won't leave, they still have to pay the rent in the meantime, obviously, because that's in reach, you know. And then they have to get the bailiffs in. And once they get possession of the property, they get possession. However that may be, they still can't re-let it. Is that correct?
That's right. Yeah, if that's within that 12-month, 16-month period that I was mentioning earlier on, then no, you are at risk of a fine and you are banned from doing that.
Okay. So, Paul, you're getting a lot of councils telling tenants to stay put. It's absolutely rife. It's happening all the time. That's why I think with this spike in Section 21, you're going to see a bigger rise in temporary accommodation issues, an unintended consequence. So tenants that won't leave or can't leave on a Section 21 notice, the notice has expired. There's a deadline day, a cut-off day for the last Section 21 notice can be issued on a claim is by the 31st of July. So obviously we've got lots of claims. Explain what we're seeing at Landlord Action, and presumably we're seeing a massive rise in instructions.
Yeah, so in that particular week I referred to earlier, lots of instructions were coming through. We served notices left, right and centre for landlords. It was going. That means 2 months of your Section 21 takes you to the sort of beginning of July. Now, you've got a month, effectively, to issue the claim. So that's seemingly fine if you're in that situation. But one, you can't delay. You've got to get on with it. So we will be contacting our clients to say, has the tenant left? No, fine. Let's get on with it. So we need clear instructions quickly so we can get on. That's the first point. So instruct your solicitor without delay once that notice has expired, because there is only a month to go. And then the second point is, really, it's about the way the courts are working, and they have been like this for some time. You send in a claim form to the court today, even today, you won't necessarily get notification from the court that they've received it, that they've processed it, they've taken your fee and all of those sorts of things. And you get a case number, exactly. Yeah. But you won't necessarily get that as quickly as you think you might.
Let's talk about this. This is top tips, and that's why we're doing this Landlord's Own podcast for landlords in this position. And obviously, you know, I get contacted a lot of the media and questions, and it's all been about Section 21 with vendors' rights. So what we're doing at Landlords, because we've got so many claims to issue for landlords and agents and corporate landlords and insurance companies nationwide, is the courts are falling down. Right, the administration's poor. We know the wait times, this, that, whatever. You know, you can send a case to a court, they sit on it, and then they send it back saying, no, it's another court. So you've got to make sure there's a court reference website that you can go on, isn't there?
There is, yeah.
Make sure that you issue it and send it to the right court. Trusting the post is an issue.
Yeah.
What we're offering a service, we're charging clients extra to hand deliver the court bundle to the courts. And even taking a picture that we put it in the court to make sure we delivered it. Yeah. What happens if, you know, they're taking ages to issue it and it goes past the 31st of July? What will happen in that instance? Because it could be that there's going to be some administration errors, and because courts can't cope administration-wise, or they make mistakes, because we see courts make the mistakes. What happens in that instance?
Well, it's what we've already had before. So, for example, beforehand, if you served a Section 21, it would lapse after 6 months. So if you then served...
By the way, that was my idea.
What?
On the Deregulation Act. When I gave evidence in Parliament,
right,
I put forward that a Section 21 should have a 6-month lifespan.
Okay. So,
it's now going to be going on.
Right, sure. But so we've had that for some time now. And what that means is when you're in that sort of last couple of weeks of the notice, if you then say, right, for whatever reason, you haven't issued your claim, you then decide to issue which you could have done after 2 months, but then you don't. In the last couple of weeks, before it lapses, you issue your claim, i.e. you send it to the court with the correct paperwork, and for some reason the court don't receive it, or don't process it. Or sit on it. That's what I mean, really mean. As you say, send it to another court and all those sorts of things, but let's say they just don't do anything with it. Time passes. It then gets to the time where it gets issued by the court, but it's after the 6 months. The notice has expired. The notice is lapsed, sorry. It's quite important to get those different words there. If the notice is lapsed and it's issued after that, then the claim will be dismissed once it gets in front of the judge. So that analogy is the same
but that falls outside the landlord's hands.
Absolutely. And the same will apply, with this 31st of July cutoff.
I can see. I'm going to say this live on air.
Go on.
I think that you need to be writing a blog on Landlord Zone about this issue. I think it's a real problem issue. I think so. That's some homework to do for you.
Thank you, Paul.
Because I think that I really think that that's going to be a big issue. Yeah. I think we worry about that a lot.
No, it is a concern. So in that first week in July, when a lot of our notices will be expired, we'll be getting onto our landlords to say, give us instructions immediately.
And hand deliver them to the court.
And then say, hand deliver them. It will cost more money, but, this is...
At least it's got it. The problem you've got now with court, you can't even go to a desk.
No.
They won't even let you into a desk. I mean, I know...
Some courts are better than others.
Some courts are better. I remember being a 16-year-old outdoor clerk going to courts initially, going to all to the courts and the High Court and stuff like that.
Friendly person.
You can't go to the courts now. You can't even, you can't even deliver things by a certain date. It's becoming unbearable, really. And the court services and the user service experience, I think, has been an all-time low. I mean, that's just my view. Yes, they want more digitalisation, and then of course it comes back to the conversation when we were looking about the Deregulation Act coming in. We were looking about banning Section 21. I can tell you now, I was on the working group for housing courts, which was prior to COVID. I went up to Leeds and there was a working group, and we were going to have housing courts, which in principle would have been great because the courts would have had investment. That investment still has not been put in. David Lammy, our Justice Secretary, said that they're going to invest £50 million into the court system. The Conservatives should have done it previously for reform renters' rights. And I think because that hasn't been done, that's added to the landlord panic, unfortunately. But the court system needs to be much more efficient, which is an issue, because time delays is the biggest worry for landlords, especially if you're not getting your rent, Paul.
Yep, I agree. I mean, we work with the system we've got.
So, Paul, one of the Achilles heels we're seeing at Landlord Action, and which I've been calling out a lot in the press, is bailiff wait times. We have a bailiff shortage. I think there's about 250, 300 county court bailiffs in this country. Right. I've been working with the High Court Enforcement Association, with Property Mark and the NRLA. We were looking at doing a campaign so that landlords, if they went to court and they had severe rent arrears, they should have the mandatory option of using a High Court Enforcement Officer to carry out an eviction and to carry out quicker evictions. We waited 15 months for an eviction date at Clerkenwell County Court. If your landlord, and bear in mind, the average rent arrears now case in London is £12,000 a year. It's going up more and more with the lead times, especially if rent's not being paid and your interest has gone up on your mortgage. It's worrying times, and that's why I'd always recommend landlords to use rent guarantee insurance, have a guarantor in place. We know that referencing is going to be much more stringent. What are you seeing on the ground with regard to bailiffs? Because I presume that's the worst issue with the courts. Is that fair enough to say?
Yeah, I mean, I think if it was panic for landlords, it's meltdown when you get to bailiff stage. It really is. The point about getting possession is that you can't. We got that possession order. It needs to be enforced. And a county court, unless it goes to the High Court, a county court possession order cannot be enforced other than.
And what we do at Landlord Action. On every single Section 8 case we do, we plead Section 42. So when we have a hearing day, and we do 40 hearings a month, or somewhere, however ridiculous month we do all over the course, we make sure our advocates would always press at the hearing.
Absolutely.
Transfer up to the
Yeah, and I think judges have been a little bit more lenient, but
What would
broadly,
you say percentage-wise?
I mean, it probably was sort of the point is it's supposed to be an exceptional circumstance.
Yeah. And now it is for most landlords because the rents are too high.
But the problem is if you've got £10,000 rent arrears, that's probably not exceptional anymore. So I think we're still at quite a high or low percentage of cases being transferred up. So it is a nightmare.
We have a lot of sister companies, as you know, My Deposits, Client Money Protect, and our other sister company is the Property Redress Scheme. Property Redress, what we did in COVID is we set up a mediation business. Yep. And I'd highly recommend our Property Redress Scheme service of mediation.
Avoid the call.
We have trained mediators, got some great mediators where we try and do deals between landlords and tenants. When you do a deal, you get a deed of surrender signed, which is really important to confirm that the tenancy is ended.
Yeah.
And then obviously you would make sure that you wouldn't give the money over until you get the keys.
Yeah.
Have a witness, make sure it's a legally binding document. But I think that is the norm now. And I think, what I would say to landlords, this is a business. It is about professionalism. The new world now has forced us into dealing with risk and understanding risk, understanding compliance like never before. We know with regard to renters' rights, the risk is if you have a problem tenant not paying the rent, is non-payment of rent. How do you afford that and deal with that loss? How do you protect yourself? How much more stringent are you with referencing? And actually, property management is becoming much more harder to deal with. And getting an expert, maybe a letting agent, I think is really prevalent now. But I think the biggest risk, and I always said this, with renters' rights is going to be civil penalty notices and rent repayment orders. I think they're the biggest risk that we're going to see for landlords. And one thing I want to talk about, we talk about the information sheet. I've commented a lot in the national press about this. The end date is the 31st of May, which happens to be my birthday, right, for the information sheet. They've got 1 month to serve this information sheet, where in Wales we had 6 months. I do hope that the councils will have some sort of leniency and understand that. And I think the problem you've got is that you've got over 600 councils. I think some of them will see landlords as a cash machine, and they've been quite ruthless with that. And that I don't think that's going to help, because we need good landlords to stay in the sector. And of course, if you look at the course of time, what's happened when it comes to landlords aren't really feeling the love. I don't know, it's a business, but at the end of the day, they are housing providers, and without a private rental sector and small landlords, they're really well needed, aren't they?
Yeah, no, I agree. I mean, I think the sort of scale is sort of 7,000, that sort of fine level. I think an initial fine is going to be lower than that, but they are going to be in the thousands rather than the hundreds. And I think, repeat offenders is going to go up 30, 40,000. So yeah.
That could financially cripple a landlord.
So they've got, the councils have got the sort of scope to do it. It has a massive impact on landlords. But yeah, you would hope there would be some common sense.
So Paul, closing comments on this podcast. Hopefully we've given loads of people loads of advice, loads of nuggets and pointers, when it comes to property management, and also if they have a problem tenant and what the new world looks like. So look, we know the market is shifting rapidly. We know that there will be properties for sale on the market. I think the market might come down a little bit. But obviously, I think tenant affordability and rents are still going to be an issue. We've got the political landscape possibly changing, or what's happening. Compliance, preparation is really important. Understanding the rules and the regulations. The era of self-managing process, looking at your business reviewing, I think that makes sense. Managing a property was easier prior to the 1st of May. I think that's fair enough to say, isn't it? Yeah. And the documentation and how you witness and how you document what you do and how you do it is really important.